Good afternoon, everyone. Thank you very much for joining us for this important webinar. We wanted to make sure that we spread the message to everyone with respect to the upcoming deadlines, and we found that this is probably the best way to do that. So thank you very much. Appreciate you. Also wanted to thank our business development folks, Anthony, Joe, Mara, and Mike Moore. Thank you. So the agenda essentially that we're going to cover, it's going to be some introductions, which I will do. We will talk about statute of limitations, the current status of the cases that are in litigation right now. We're going to discuss bad faith, the Louisiana Insurance Guarantee Association cases. We'll discuss what documents are needed to review claims, the next steps to take immediately. We're going to cover some frequently asked questions, and then we're going to have a live question and answer session where you can ask your questions. So in asking your questions, on the top right, there is a button. It's called Q&A, and it has two bubbles with a question mark. You can click on that, and during the presentation, you can ask your questions. You don't have to wait until we're done. Those questions will be monitored, and then we will answer those questions after we finish our presentation. So our Louisiana office is here in New Orleans. We are in downtown New Orleans, and frankly, I'm really excited to introduce you all to the attorneys in our New Orleans office. They're here with us, and you'll be hearing from them throughout the presentation. First, we're going to cover a little background about Merlin Law Group. I think the most important thing to remember is that Merlin Law Group only handles first-party property insurance cases. That means we represent policyholders throughout the entire country. We have 11 offices. We have been in practice for 38 years. Mr. Merlin started this law firm in 1985. There are 45 attorneys in our firm, again, only handling first-party property insurance cases. And we've recovered over $2 billion in representing property owners. As you can tell by looking at Chip Merlin's states that he's been licensed in and myself, most of our attorneys actually are licensed in different states because we do handle these cases across the country, especially in Louisiana, and because we only handle one area of law, which is first-party property insurance. So let me introduce to you our attorneys here in the New Orleans office. Charles is a former general contractor. His family was in the general contracting business. He started climbing roofs and helping his dad work on roofs when he was 7 years old. And so he has a great background with respect to the type of claims that we handle, which is all property claims. And he's licensed in several jurisdictions, as you can see. And of course, Charles dedicates his entire practice to property insurance claims, just like Reese and Lucas. Reese is a former officer in the U.S. Marines. He had his own successful practice, when he decided to join us and dedicate the rest of his career here to property insurance claims. Reese is actually born and raised here in New Orleans. Lucas has been in practice for 15 years. He also had his own successful practice, and he's lived here in New Orleans for 36 years. And these are our New Orleans attorneys, and we're very happy to have them. Without further ado, I'll
Can you guys hear me?
We can hear you good, Reese.
All right, sounds good. Hi everyone, I'm Reese Gassery. So what's happening now? What are we doing right now? Well, now is the time for filing lawsuits. It's not the time to be trying to get any sort of last-minute settlements or negotiations. Obviously, we're always working on negotiating some sort of resolution for our client. But right now is really time to file suit. I myself, recently had a settlement on July 13th, and I have reasons to worry about that as well. But I'll explain that within the next 2 slides. We have a very important date coming up, and so it's time to file suit. And what's that important date? Well, it's the statute of limitations deadline. Generally speaking, in Louisiana, for any sort of breach of contract, there's a 10-year statute of limitation. However, the legislators here have allowed insurance carriers to reduce the time for filing suit down to 2 years. And I can tell you almost to a man, or to a carrier, I should say, all of them have reduced that time down to the 2 years that they're allowed to. So Hurricane Ida occurred on August 29th, arguably August 29th and August 30th. And so that deadline is August 29th of 2023. And so what happens if you fail to meet that deadline? Well, you lose the right to what you're owed, or I should say your client loses the right to what they're owed. If there was a cause of action, all those rights are now extinguished. They're terminated. They lose their ability to enforce that policy. And we know that this would obviously bring our clients financial harm, as they would require some other sort of financing to finish any repairs. That could be potentially taking out loans or going into their savings. And how does that affect you all? Well, it affects you all directly, because obviously you guys might have outstanding invoices for your clients that your clients are not able to pay. If they don't have the money, if they haven't gotten their money from their carrier and things get tight for them, well, from experience that things may get tight for you. They may, not be able to pay you. And so going back to that first slide that I spoke about, why we're filing suits now and why I myself have reason to even worry about the settlement that I agreed to last Thursday, July 13th, is because there's approximately 41 days into this deadline. And quite frankly, anything could go wrong. Maybe there might be an issue with the way the release was drafted and we have to send the release back. There may be an issue with the time it takes to cut the check, or the time it takes for the check to be issued to us through the mail, or maybe there might be an issue with the payee listed on the check. And, if that check isn't deposited by the time the deadline runs, we want to make sure that we're prepared to have that suit filed in order to preserve our clients' rights.
There is some good news, such as it is. I know that everybody kind of cringes at the idea of filing suit, and especially on the other end of the table, people think, wow, filing suit, that's really going to be a drag. And sure, I understand a lot of people don't like attorneys, but the good news is that these jurisdictions have been through this before, and almost all of the jurisdictions which have hundreds of hurricane cases have adopted what are called case management orders, and they are streamlining the process specifically for hurricane cases, as it says on the slide, except Baton Rouge. So that's the Middle District of Louisiana has not adopted a CMO, but Western District adopted a CMO for Hurricane Laura, Hurricane Delta cases. Eastern District has adopted a very, very similar CMO for these Hurricane Ida cases, and all of the state jurisdictions, all of the local parish jurisdictions have adopted some sort of case management order. And what that means is these hurricane cases are getting special rules when they go through court, and it's helping them move quite a bit faster. So we file suit. The defense has 30 days within which to answer. Once they answer, that clock starts ticking, and they've got 30 days to turn over initial disclosures. We turn over our initial disclosures to them. They turn over their initial disclosures to us. And then we have an informal settlement conference with the defense attorney. And after that, within 60 days of that informal settlement conference, that case is going to go to mediation. It's going to get set for mediation. And at mediation, these cases are closing. Overwhelmingly, at mediation, everybody wants these cases to close, and they are closing. So it's been very beneficial to have these case management orders. It's good for plaintiffs. It's good for our clients. Like the slide says, over 90% of the cases close at mediation. The ones that don't close at mediation close generally before trial. It's very rare for these cases to get all the way to trial, though it does happen. It has happened. And Louisiana's bad faith statutes are making these very beneficial for policyholders. We've got great bad faith statutes. Chaz is going to talk about those in a few minutes, but it allows us to really get our costs back, get some damages when the insurance companies have been acting in bad faith. Next slide, please. This is just an example. This is the case management order from the Eastern District. So what this means ultimately is that all of the cases that go through the Eastern District Court, the federal court that presides over the majority of the areas which were hit by Hurricane Ida, all of those cases will follow this procedure, and it's been very beneficial for our clients. It's been good for everyone all around, because we get to use these great bad faith statutes.
Good afternoon, everyone. This is Chaz Cicero, and as Lucas said, we throw around this word bad faith a lot. You probably have heard it many times the past few years, dealing with all these hurricanes and storms, not just in Louisiana, but across the country. Bad faith is a way that we kind of maximize the value of the claims. In Louisiana, we have very strong consumer protection statutes. We'll talk about them more specifically in a moment, but in short, there's a few elements that are required to be proven. One is satisfactory proof of loss. Two is the timeline, 30 or 60 days, and a failure to pay within that timeline. And then three, such failure must be arbitrary, capricious, and without probable cause. Now, that means kind of without a good basis, as the statute says, arbitrary. Obviously, you're going to work up your estimate and things like that and send that into the insurance company. The clock will definitely start ticking at that point. But something a lot of people don't know is Louisiana case law supports the assertion that the satisfactory proof of loss is satisfied when the insurance company sends out their initial adjuster. And it's their initial inspection as well as their failure to discover damages that they should have. So the insurance company can't just cover their obligation, to act in good faith by just sending a warm body out there like we saw after some of these hurricanes. Someone with a clipboard and a tape measure and a pen, and then they write an estimate for $5,000. That the insurance companies are held to a higher standard, especially in Louisiana. And failure to abide by that standard can subject them to some pretty substantial penalties. We have two main statutes in Louisiana. The main one, we call it 1892. And this one provides that if an insurance company arbitrarily and capriciously fails to pay the full amount due on a claim within 30 days after that proof of loss, like we said, we make the argument from the initial adjuster inspection, they should have had everything they needed to evaluate the claim. And if they fail to pay the amount due, the penalty is 50% of that difference in value. Let's say they came out and wrote an estimate for $10,000, and you come out and you find out the true extent of damages is actually $100,000. Well, we would demand obviously the $100,000 that's owed, but also a 50% penalty. Additionally, the statute authorizes recovery of reasonable attorney's fees on top of both the amount due and the penalty. It's important for that distinction. And another often overlooked part of this statute is this idea of costs and what costs can be recovered. As we argue, if you had to get a public adjuster or an appraiser involved because of the bad faith of the insurance company, well, those costs should be recoverable. We include them in our demand and we try to recoup them. This is important for you because we can demand the public adjuster invoice, any appraisal fees, any expert fees that have been incurred, filing fees, any of these costs that were, due to the undervaluation and the failure to properly adjust the claim. We do have another statute called, we call it 1973. This one is a failure to pay within 60 days when that failure is arbitrary and capricious. This allows recovery of consequential damages as well as a potential penalty up to 200% of those damages. This is different than the amount due on the claim, and you can only recover one penalty. But sometimes these penalties or these damages can include mental anguish, increased repair costs, and as we also argue as well, those can include the costs that we mentioned in the previous statute, giving us two bases, because we always get into that fight over those costs during mediation. Appraisal fees often are part of the policy to be borne by the policyholder, but we argue that appraisal or hiring a public adjuster would not have been necessary, and these costs are a consequence of the insurance company's breach of good faith and fair dealing. You can also receive attorney's fees on the amount due, damages, and penalties, but you can only get one penalty under 1973 or 1892. And typically, the penalties we see are under 1892. I'd say 95+% of the time, those are more likely to be recovered and a better basis to argue for them. With all that being said, though, the takeaway I want y'all to get from this is that your clients have cases of value. There's obviously those outstanding cases where you just haven't been able to get a final settlement or haven't been able to resolve the damage disputes. Obviously, there are cases in appraisal, but you still have to file them because the appraisal, if they pay the appraisal award, great, you're leaving bad faith penalties and attorney's fees on the table, but maybe they don't pay your appraisal award. We've been seeing that a lot more, and we have to go in and fight that to compel the appraisal award. That requires a lawsuit, and if you don't file before the deadline, you're good chance you lost your chance. As well as another one that people might not think of are claims that you think may have been resolved. And I put those in quotes because let's say you got someone an extra $100,000. Well, if it was more than 30 or 60 days, there's a good chance that they may be owed compensation for the penalties and the attorney's fees and the annoyance of dealing with that, the public adjuster invoice, and all these different things. So even if there's a claim you think that may have been resolved, if they haven't signed a final settlement release or agreement, chances are we could evaluate that case and determine there may be some more money out there in terms of penalties and fees.
So that brings us to the LIGA cases. Well, what you need to know is that the LIGA cases, you still have to file suit. Those cases will fall under the case management order as well. However, for carriers that have gone into receivership, unfortunately, the bad faith statutes that we just talked about don't apply. You do not get penalties or fees. The good news is by filing the lawsuit, you preserve your client's right. Obviously, if you don't file the lawsuit, then their right of action is extinguished, and then they recover nothing.
And important to know, for us to review a claim, which we would like to get done as soon as humanly possible, preferably within the next few weeks, we need to review these claims to, get all the information up so we can get a lawsuit drafted and filed. We're definitely going to need a copy of the policy, any photographs that confirm the damages between, from the storm compared to the, the various estimates that, we'll have out there. We need those estimates, any prior estimates from the insurance company, any prior correspondence, denial letters, coverage letters, things like that are important for us because not every case is the same. Sometimes there's a pricing issue, sometimes it's a coverage issue or a scope issue. So we need to figure out what are we going to be fighting in this lawsuit. And then an idea of the amounts in dispute. You guys know these claims very well. What's the claim pay timeline? if there've been multiple payments, if there's been multiple payments, there might be bad faith penalties owed on prior payments, as we discussed, and even on what might have thought to be a resolved case. But these are the bare bones of what we need. Y'all are usually very good at helping us get these documents. We appreciate that a lot because it helps us out immensely. So these are the things you need, and we definitely like to get these in the door sooner rather than later.
And ultimately, it's been 689 days. 689 days is a lot of time. Arguably, that clock starts running from the day of the hurricane for them to start paying. And so if you've got claims that are open 689 days, if you're being delayed or you feel like a case is being delayed, if it's being delayed unintentionally, whatever, if it's being delayed intentionally, I assure you the carriers know that the 730-day mark is the mark. 41 days from today is the mark after which we will not be able to help you legally. There will be no legal recourse. You'll be stuck with having to ask very nicely to hopefully get what you want. And I just don't think that that's a great plan. 689 days is a preposterous amount of time for them not to have paid. So if you've got an open claim still at this point, the time is now. If the time has come to file that suit. Next slide, please. Importantly for us, lawsuits take a lot of time, and that 41-day mark is it's alarm bells are ringing if we've got a case and the prescriptive period runs in 41 days. We've got to get that case in hand. We've got to get as much information as possible. We've got to talk to the clients. We've got to review everything. We have to write the lawsuit. We have to get it filed. And any slip up in that time period, 41 days is just not very much time. So please, if you do have a claim out there that needs to be resolved and it's being delayed and they're trying to stretch it out past the 730-day mark, get it to us as quickly as possible because lawsuits take time. We've got to have the time to prep and file these cases. We do not act like the MMA guys and file 1,500 cases in one day. That's not the way we operate, for good reason, and we don't want to do that. So if you've got a case, please give us the time to give the case the time that it deserves, really. This is the number. Please call this number, email this email address. We've got a team that's ready to take your calls, client calls, you and the client together. Give us a call. If you don't speak to an attorney directly, we aim to have you speaking with one of us inside of 30 minutes. If you got a claim that's out there, we're ready to take it. We want to talk to your clients. I'm sure they've got a lot of questions. We're happy to help, but ultimately these claims need to be filed. If they're still open at this late date, don't wait. The carriers are dying to get you past that 730-day mark. They know the 730-day mark and they know that it's coming. So please don't let it get there. Get the case into our hands, please.
Thank you, guys. So I will cover some of the frequently asked questions and then also assist with the question and answer session. First question we typically hear is why hire a lawyer? Well, as you've heard, there's an absolute need to hire a lawyer in order to get that lawsuit filed. We have 41 days left. Why Merlin Law Group? Well, Merlin Law Group, again, only handles first-party property cases. We've been doing this for 38 years. We literally have 45 attorneys that collaborate on a daily basis on how to best serve our clients and beat the insurance carriers. Some of us are former property insurance adjusters. Chad, for example, is a former general contractor. We're very familiar with damages and obviously what it requires and what is needed in order to have proper estimates. In addition to that, Merlin Law Group has a very good reputation. We've been appointed as counsel for different courts, both federal and at state level, to assist the courts with catastrophic losses, such as the building collapse in South Florida. Chip Merlin worked on that specifically and handling all of the insurance coverage issues. And we've also been appointed by the court systems, again, in state and federal, to assist the courts with handling the influx of hurricane losses. We've represented the Port of New Orleans. We're currently representing other municipalities and government entities here in Louisiana. So we think we're probably the best qualified firm for your clients. What do we charge? Well, typically on a contingency, most firms charge 33 1/3 and 40%. What we've done is we've agreed to charge 30% only in this situation. These lawsuits need to be filed. We're reducing the fee down to 30% in order to get the lawsuits in and get the cases resolved. The next steps are really to contact that phone number or send us an email so that we can contact you and your client and speak with you all about your case. Determine if it's a case certainly that has value, a case that needs to be filed, and get that done as quickly as possible. 41 days is just not long enough to wait. How long does it take to resolve a claim? Well, based on what we've talked about earlier today, the average, depending on when these scheduled events take place, the settlement conference, the mediation, and when all of that is scheduled, we're looking at approximately somewhere between 90 to about 150 days on average. Again, over 90% of the cases get resolved at mediation. If they don't get resolved at mediation, they get resolved shortly after mediation. Is there a case that could potentially go to trial? Yes, it's possible. And we have a trial team to handle that. We have a trial team that tries anywhere between 2 to 5 cases a year, and they've won all of the cases since 2016. That is a very good track record. Again, the only trials we handle are first-party property trials, so we've gotten pretty good at them. How does the contractor or public adjuster get paid? So the contractor public adjuster in Louisiana, as you know, can only charge on an hourly basis. Essentially, when we accept a case, we will continue to work with the contractor and public adjuster in terms of prepping the case, getting the lawsuit filed, and even all the way through mediation. When it is over, when the case settles, the contractor or public adjuster sends us an invoice. We will then share all the information with the client. We'll prepare a closing statement, and then the contractor gets a check, the client gets paid, and the money gets dispersed. Is appraisal an option? Appraisal could be an option, but a lawsuit still needs to be filed even if you decide to put your case in appraisal. You cannot just put your case in appraisal and assume that you've complied with the statute of limitations. That's not the case. You have to still file a lawsuit. Now, considering the case management order that is in place, in that all of the damages are being resolved, both your contract damages as well as your extra contractual damages, your bad faith, your attorney's fees, your costs, and it all gets resolved at one time. That seems to be a faster process, at least that's what we've experienced, than going to appraisal, resolving your breach of contract damages, and then having to go through the mediation process to then resolve your extra contractual damages, attorney's fees, and costs. So while appraisal is an option, at this late state in the game, we don't think it is the best option. Okay, let me get through the question and answer sessions real quick, and we'll address some of the questions that have been asked. Okay, first question. Labor and material prices have jumped sky high due to inflation, but the insurance company will only pay according to its pricing guidelines. How do you fight that? Reese, let me see if let me send that question over to you if you can please answer that.
Well, the answer is that we fight to assert what the actual cost of repairs are for our clients. I mean, clients aren't bound by what the carriers are displaying in the Xactimate, because Xactimate isn't necessarily reflective of the prices that clients have to pay to their contractors to get their repairs done. So that's what we assert as far as the cost of repairs, and that's what we fight for.
Thank you for that. Okay, the next question. If a home is only partially damaged, but it will look weird if half the vinyl siding is old and half is new, assuming here that the carrier is not paying to replace all of the vinyl siding, does the insurance company owe for matching? Chaz, would you mind answering that question?
Sure. So when we get into this issue, different states handle it in different ways. Some states have what's called matching statutes, where they explicitly require the insurance company to match, at least on certain sides, certain parts of roofs. But in Louisiana, it's handled. There's some case law that discusses this. It was a case law in the context of carpeting replacement. And Chip has a great blog on a blog post about this, where the important issue in that case was expert witness testimony that showed that if they only replaced part of it, they weren't really being made whole because they suffered a diminished value of the property. And that was the basis to show, why they were entitled to a full match of that carpeting in that area, because you would obviously see a line where there was different carpeting and it just wasn't functional. There's also arguments we can make about manufacturer specifications, and some manufacturer specifications don't allow you to mix and match and replace. And when that's the case, we try to we make the argument that you're owed that full wall, I guess I would say. In general, like I said, we don't have a matching statute. We'd like to have one. That would be great, but there are bases to to increase the scope of it. It's something that we're usually able to handle in mediation.
Great, thank you. Okay, the next question is, I have a commercial loss where the building was near the coast. The insurance adjuster is saying the damage isn't covered because it was caused by storm surge or waves, not wind. I'll take that one. That's just generally speaking, the way to handle that situation is you will have to hire typically an engineer and a meteorologist to determine the time period that the surge arrived at the property. Also determine the time period of the winds and how strong the winds were, the wind velocity, the wind speeds, the wind gusts. And then based on the timeline and whatever evidence is left, sometimes it's a slab, and we handled plenty of those cases in Texas after Hurricane Ike. But sometimes the property's still there, there's partial damage. And so with the engineer and the meteorological information together, they can essentially look at everything, look at the timeline, and be able to segregate the wind versus the storm surge. And that's something that needs to be done and worked up at the beginning of the case in order to successfully resolve the case in mediation. Let me get the next, let me read the next question here. My client's business is very badly damaged, but the insurance company is refusing to pay for the contractor's overhead and profit. The business doesn't have the cash to advance overhead and profit, and the contractors won't get started without it, so the client is stuck. Is there anything they can do? Lucas, is that a question? Can you take that one, please?
So yes, what can someone do if they're not going to pay overhead and profit and you need to hire a contractor? A lot of people will do the work themselves, which is obviously not the greatest set of events for them, but a lot of people looking for contractors and there's no contractor in the area. O&P is owed whenever a general contractor service is reasonably foreseeable, so they do owe that money. If they're refusing to pay it, then I hate to sound like a broken record, but lawyer up, hire an attorney. Let's get the case filed. Let's fight it on our turf, because that's where it needs to get handled.
Chaz, do you want to supplement that answer? I think we were talking about this issue earlier.
Yes, we've run into this issue. It's very frustrating for a lot of contractors, especially a lot of roofing contractors. treated poorly by the insurance industry. But yes, the Louisiana recently changed their law to clarify that. In some states, they go by a 3 trade, you know, if you need a roofer, painter, drywall, mitigation, stuff like that. But we don't have that hard and fast rule. That was kind of a convention, and they decided, the Louisiana legislature decided to change the law to state clearly that whenever a general contractor's services are reasonably foreseeable, and I've seen cases where that's just a roofing and mitigation company, they should be paying overhead and profit. They should be paying overhead and profit on just about most cases, unless it's a simple roof repair. Because even with a roof replacement, you have multiple trades. You have labor, you have demo, you have skilled roofers as well. So I would argue that, and I definitely do argue that a general contractor's services are reasonably foreseeable in those cases.
Thank you. Okay. So Ray submitted this question. The question, I'll read it. I'll read it verbatim. Javier said that the only thing that a PA can charge is on an hourly basis. Isn't it the case that a PA can also charge on a flat rate basis as well? Lucas, can you take that one, please?
Yeah, certainly. So, yes, PAs can charge on a flat fee. What they cannot do is do a contingency fee. That's the most important part. They can charge a flat fee. They can charge an hourly fee, and flat fee is totally reasonable. That's legal. That's fine. What PAs must avoid is the contingency fees. That's not allowed in Louisiana. Not at all. Stay away from contingency fees. Get an hourly fee, or like Ray says, you can do a flat fee. That's correct.
Great, thank you. All right, so appears to be the last question here. The contractor estimates I've gotten are $120,000 more than the contract estimates the insurance company has received from their contractors. How can I break this log jam and still hire contractors that we want to do the work? Chaz, can you take that one, please?
Sure. A couple things about this question. These things come up occasionally, where the insurance company is trying to steer the policyholder into selecting a certain contractor, or what I mean, I've even seen them pressuring them to fire their contractor because the insurance company claims, oh, they charge too much or they're playing hardball, and that's ridiculous. That's against the law in Louisiana. I will be happy to bring that up in mediation if that ever happens. But you're entitled to hire, you know, the policyholder is entitled to hire who they want. It's an arm's length transaction, and after a storm, I mean, you can't expect there to be a whole lot of options available, but you also don't have to settle for subpar work. And a lot of times this work, you know, costs more. So the $120,000 difference is, you know, this is where it's important to get good experts, to get good estimates, good photographs and documentation, because what we're going to do is take that $120,000, we're going to file a lawsuit against the insurance company for that. That will break the logjam. It requires them to respond. We're going to ask for $60,000 penalties on top of that, and then reasonable attorney's fees and costs on top of all of that. That's going to send a message that, you know, what the insurance company is paying is simply not enough. There's options to deal with that as well, like I said, through the appraisal process. But since we're so close to the deadline, if you've got a delta, as we call it, of 120,000, you need to get a lawsuit filed immediately.
So this is Chip, and I just wanted to say, I want to make sure this is crystal clear. If you have an open file, the end is near. That means if you have a case, it's an appraisal. It could be an arbitration. It could be all kinds of things. You're waiting on a check. It's not done, and there is not a release that's been signed. You absolutely should have the case placed into litigation, even for cases that you might have had that settled and got a whole bunch more money for, and no bad faith case was brought. Those cases, at least the client should be aware of them having rights to bring a bad faith lawsuit. But if you don't do that by the end of next month, the end will get you. So the big point on all of this, guys, and we can go over all kinds of these questions, is that You need to get these cases into litigation, period. And especially, one more time, I'll say it. You might have a case that's in appraisal. You need to file a lawsuit. What happens if you get an appraisal award and the insurance company says, ha, you got an appraisal award, but we're not going to pay you. And you say, well, we're going to sue you. Well, if you wait too long, you can't. You're just going to be holding on to an appraisal award. So for heaven's sakes, I mean, I really pushed on this. Get the cases, get the clients into litigation. Our experience has been very favorable so far. I think that's what Reese was trying to say. And that was kind of the point of all this, today. Are there any more questions? You guys have done a great job answering them. I just had to say that. I couldn't help it myself. I had to jump in there and make sure the point was crystal clear for everybody.
And we truly appreciate that, and thank you. I don't think there's any more questions. I really appreciate everyone's time. And Chip, thank you for joining us on this. And I hope everyone has a great afternoon and a great week. Thank you, everybody.